State of the Nation, 12 noon to 1 p.m. on Power102 FM.
Well, good afternoon. I'm Andy Johnson. Welcome to the program. There's a piece of legislation recently put on the books, 3 years ago, 4 years ago, if you're counting like that. Act 1 of 2015. I'll tell you what it is. It's an act to provide for the procurement and disposal of public property in accordance with the principles of good governance, transparency, integrity, and value for money. It's the establishment of the Office of the Procurement of Procurement Regulation in Trinidad and Tobago. Every time there's a discussion about corruption or the perception of it in the country, for years we have been told that what we needed was procurement legislation. Well, that's the legislation that was passed in 2015, and in 2019 the office is just getting going. The chairman is Mr. Munilal Lalchan. He's been, along with number of his members of the team thus far, they've been holding public discussions and, not sure you could call it consultations, with different groups of people across the society. The most recent one was a joint affair organized by the Rotary Club of St. Augustine and the Greater Turnapuna Chamber of Industry and Commerce. On the basis of that, I thought it would have been a good idea to invite Mr. Lalchan to share some of the perspectives and the work of the Office of Procurement with our listeners. Mr. Lalchan is our guest for the full time we have available between now and 1 o'clock, and we hope to be able to take some of your calls on the issue. Good afternoon, sir.
Thank you very much, and good afternoon, Andy, and good afternoon to your listeners on 102. And it's indeed a privilege to be here to share some thoughts this afternoon with your listening audience.
Yeah, and we feel privileged to have you. One of the things that I pick up is that my sense was that because in a lot of cases, agencies such as these are almost cloistered, and you know, it's like pulling teeth to get their representatives to come and face the public. But I listened to that presentation in at the Center of Excellence a couple of weeks ago, and I listened to talk about the sense that I get is that at least thus far, it's a very accessible agency, and there's a reason for that.
There is a reason for it, and we have been meeting on several forums with literally hundreds of individuals and organizations as we move forward, both in Trinidad and Tobago. Okay. And the reason for that is that because it's a new piece of legislation, we really do need to have as many people on board and aware of what's taking place with the legislation. Our body was appointed, the board was appointed on January 12, 2018. Yeah. But we only really got started when we started to get our first set of employees on board, and that's around July of last year. Yeah. So between July of last year and as we sit here today, we have been involved in a number of consultations. We meet literally like twice a day on 10 o'clock and 2 o'clock with different agencies, because when you look at what is the OPR, we are a regulatory body, and we were appointed by the president. It's an independent body. We don't report to any politicians. In fact, our report goes straight to the Speaker of the House and the President of the Senate, and it should be laid in Parliament at the next sitting after we submit that information. The act,
so that would be the first report?
That would be the first report. But we actually met before Joint Select Committee already of Parliament in November of last year to give an idea as to where we were and what's being done. Number of agencies, actually, when you look at who falls under the Act, just to set the context in terms of what is required, is the Office of the President, and that's the President of the country.
It starts from there.
It starts from there. The Parliament, although report to Parliament, Parliament also falls under the Act. The Judiciary, a ministry or department or division of a ministry, the Tobago House of Assembly or a division of the Tobago House of Assembly, a municipal corporation, a regional health authority, a statutory body, a state-owned enterprise, all these special purpose companies and so on, a service commission established under the service commission. And then it goes on to speak about public money. And public money is money that is received or receivable by a public body raised by an instrument from which it can be reasonably inferred that the state accepts ultimate liability, spent or committed for future expenditure, and important, D, distributed by a public body to a person. So a number of agencies, and when you look at things like the sports organization, Cricket Board, Football Association, NGOs, NCC, you name it, once you're in receipt of public money, you fall under the Act.
And just on that point, so the receipt of public monies for these organizations, but then their disbursement of it also is...
Their disbursement must be in accordance with the Act. And therefore, as you quite rightly mentioned, it's a principle-based approach that really structured the Act, and it speaks about accountability, transparency, integrity, and value for money. And therefore, we expect once public money is involved in any form or fashion, there has to be the element of accountability, transparency, and value for money. So no longer are the days when you just give the money and there is no accountability. That is no longer acceptable. So once the Act is fully proclaimed, and we expect it to be fully proclaimed by the end of March of this year, then these bodies have to be in conformance with the Act.
What is meant by being fully proclaimed, and why is it not fully proclaimed now as we speak?
Part of the Act was proclaimed in July of 2015, and the Act was passed in the House in January of 2015. The partial proclamation gave the President the authority to appoint the board, but that was only done last year in January. The board now has to put a number of mechanisms in place. Key to it was the drafting of the regulations. And the regulations were completed at the end of November and handed over to the Minister of Finance on November 30th, 2018. And that has to be placed before Parliament for affirmative resolution. And once that is passed, then all the other bits and pieces will fall in place, because we have right now staffed up to about 75%, and by the end of March we should be about 95% fully staffed. We also have to put different mechanisms in place, like the setting up of a database to put in information there to run the affairs of the public body in terms of things like pre-qualification. You see, once before, what would have happened is that there was a list of pre-qualified contractors that each individual public bodies used to maintain. And sometimes one would misbehave and get delisted from one particular public body, and they go next door. And they can do business as if nothing happened. Now you'll have one database with all pre-qualified contractors, and you'll have one list of delisted contractors, so that no longer there is an excuse whereby you can say, well, I did not know. Now you would know, and it will be a public document that will be available. So these things would be put in place, and that allows us to go into full proclamation by the end of March once we get the regulations passed in Parliament.
What causes a service provider to be delisted?
Well, there are three things that the service provider could get delisted from. One is for continuous, and the word there is continuous bad
That's the
performance.
operative term. So
it's the operative term.
So then one strike, you're not necessarily out. But if you, and I imagine under this agency, you were found to have not been operating by the rules in this particular case, and you were warned and advised.
You warn and advise, you come back and you do the same thing again. So consistently failing to provide satisfactory performance. The second thing is if you are found to be indulging in corrupt or fraudulent practices, or is convicted of an offense under the Act. Let's take the second one. If you are found to be indulging in corrupt or fraudulent practice, the members of that board and officers will be delisted, and they will be delisted for a period of 10 years before they can come back to do business with a public body. So it's a serious consequence now of being delisted. And once you're delisted, you're out for 10 years.
The members of and this board doesn't have to be a public body, but a board that is doing business with a public body.
That's right. So it's a private contracting or service providing firm that has been providing services to a public body as defined under the Act.
Okay.
See what has happened before, and there has been a lot of inefficiencies and poor performance and not meeting deadline, cost overruns. And there has never been consequences. We have heard about a number of instances of corrupt practices, bid rigging. All these things have serious consequences under the Act now, and you have to be in conformance with the Act. Not only that, but to be pre-qualified.
All right. I wanted to get some further elaboration on the point about bid rigging, because I saw it in making my own notes for the discussion. One of the things that you hear people talking about. But going back to this, the issue of members of a board of a private agency that gets delisted, which means that such a person being delisted ought not to, or will have difficulties being appointed on other boards for some period of time.
And if you try to get re-registered under your name, then we will catch that in terms of when we do the search and so on. Yeah. Of course, people will try to come through what we will refer to as the back door and go into business with other persons and be the financial front for businesses and so on. It may be difficult to uncover those things, but over a period of time, Trinidad is small enough so that when these things do happen, we have a forum where they can make a complaint to the office anonymously or in person, and we will take it up from there and investigate it. So if you are aware of somebody who has been delisted, trying to get back on the list through other means, then we'll be happy to hear from the public so that we will be able to take the necessary precautions to ensure that they don't get back in through the back door.
Yeah, and from what a couple of things you mentioned a while ago about, so companies may not be operating specifically or openly corruptly, but that the operations are inefficient and ineffective such that they will make for bad operations, and that is something that the office looks at as well. And,
yes,
and we that comes under operation.
Consistently bad performing. And we all know that sometimes it irks me when I drive on the road and I see some of the repairs that is being done and so on. And that is, to me, bad performance. Or you will fix a leak in a pipeline today and tomorrow it leaks back again. So those are issues that will lead to poor performance in terms of contractors not performing as per what is required. The key thing to this is having proper management and performance management by the public bodies to ensure that there is a clear terms of reference and a clear scope in terms of measuring performance, and the key performance indicators are things that we'll be requiring, so that you're not going to come one day and say, well, consistent bad performance. You must have the checks and balances and recording in terms of the follow-up procedures that are taking place. So those are some of the mechanisms that we will be requesting that you must adhere to.
Yeah, and so that there is sufficient here in the Act and so your performance standards that you pick these things up, so that a company, how will that get adjudicated upon? So with a service provider who is known to be delivering less than acceptable performance.
One of the things in terms of what the office is required to do is set certain guidelines and standards in terms of what is required, and these will be relegated to handbooks and guidelines. Now, the Act and the regulations is just two elements of what will be guiding the operations of public bodies. You have the handbooks and guidelines that must be approved by the office, and in those handbooks and guidelines there will be sufficient guidelines in there to guide a public entity as to what to do in terms of contractor management and performance management, and what documentation we will require in terms of the performance of the contractors. Because it's easy to come and say, well, the contractor is not performing in this manner, or they're not coming in on schedule or within budget and so on. But unless you have proper contract management processes in place and measuring and recording, those are the things that we'll be looking for, and that will be clearly articulated in the handbooks and guidelines.
Yeah. Some of the questions, a couple of the questions that were put to you at that forum at the Center of Excellence, I want to try and find a way to speak to that. I think it was Mr. Paul Leacock, the CEO of the Tunapuna Regional Corporation. Was he making a point about the difficulties sort of the local government agencies have in sometimes attracting the service providers who would perform at a certain level because of the volume of the work, the level of performance that is required? So you can't pay the big bucks to the big contractors, so you work with small contractors, but built in you have to accept some level of not stellar performance, but you want to give them to develop their track record.
Absolutely, and what we would envisage is that, and under the Act we speak about local content and local capacity development.
Yeah.
And we are encouraging the public bodies to work very closely with these contractors. In fact, what we are proposing to do is, when we are registering contractors, to do it in terms of regions. So you have the value that you can work up to. Let's say it's up to 10,000, 100,000, a million, 5 million, and above 5 million. And the categories, whether you're a plumber, you're doing carpentry work or masonry work or whatever it is, landscaping, up to that category. And then by regional corporation. So if you're looking for someone within the Toko regional, you won't go to Ikakas and get that person. And when you get them, if there are certain small deficiencies, you work with them to develop the capacity. What has happened is that this works well in the private sector. When you have to get certain types of behavior in the private sector, you get it. So there is no reason why in the public sector we should accept substandard performance. And it's not going to happen overnight. We have to consistently work. And if contractors realize that it's a fair playing field and it's level, and they realize that contractors will be given the opportunity to bid and be successful based on their capacity and the way they behave and so on, you will have more and more people coming into the that space.
Yeah, but I think a lady had asked a question as to, so you have a guideline that if you in the Arima Corporation, whatever is the scope of work that you're trying to get done, and you can't find people to deliver in that region, but somebody from Point Fortin wins the bid. You're not saying it's outlawed entirely.
No, it's not. But the first port of call should be within the region. And if you don't get sufficient contractors, then you are able to go outside. If you take, for example, the large road builders in the country, they are only in that particular area, so they would not be pre-qualified in terms of the regions. But the smaller contractors, and I tell you something we found out when we met with the school nutrition program, the kids, the meals for schools and so on. They have a pretty good system where they actually have their suppliers, the persons who do the catering in regions. And they have been able over a period of years to build the capacity and work with those. So that's a good model that we want to follow. Yeah. So we know that the model works and it is very effective in terms of some projects, and we are sure that it could work in overall throughout the country. And
there's a sense in which, from listening to it, it will provide for a certain amount of fairness and equity spread across the country.
That's right. And once we can get that message across that this is a transparent and equitable process, you would have people investing in plant and machinery to take advantage. The other thing about it is that at the beginning of the year, and this is the fiscal year, once the budget is approved in Parliament, all public bodies have to publish all their procurement activities within 6 months of the approval of the budget. This is mandatory. So you must give it...
It's under this act.
Under the act. So you have to state all the activities that you will be involved in. That gives all these suppliers and contractors an opportunity to gear up for these different activities that is coming down the pipeline. So it no longer is going to be a secret. And then you say, well, you're about to give out a contract, and in 2 weeks' time you must respond. You don't have the capabilities. You don't get enough time to plan. So that gives enough planning from the beginning of the year for all contractors to be aware what's coming down the chute.
All right, I'm going to ask you to hold it. Let's take a break. We do some news headlines, and we come back. Our guest, Mr. Munilal Lalchand, Chairman of the Office of Procurement Regulation, Trinidad and Tobago. Stay with us. This is State of the Nation.
State of the Nation, 12 noon to 1 p.m. on News Power 102 FM.
Welcome back. Our guest, Mr. Munilal Lalchand, Chairman of the Office of Procurement Regulation in Trinidad and Tobago. And in the break, we were talking about some interesting things about penalties under the acts and the powers of the office, and how these things become effective.
Well, Some of the powers that the office has in terms of if you don't follow procurement according to what is required under the Act, the office can consider those to be illegal and void. And there are also some requirements in terms of if there is an alleged breach of the Act, we can investigate on our own initiative or upon complaint from any party involved in public procurement or disposal of public property or any member of the public. And that will cause us to investigate. There is also, you would have mentioned bid rigging.
Yes.
Bid rigging is collusion between persons for the purpose of manipulating the procedures. And we all know what bid rigging is about. Now, the consequence for bid rigging in terms of what is, if you are caught in terms of bid rigging and you are found guilty, the conviction when found guilty is $5 million and 10 years in prison. No, of course.
It doesn't depend. It's not dependent on the size of the contract or anything like that. It's a straight. That's a penalty.
Yes. In the last session I had with the Trinidad and Tobago Contractors Association on Friday, that question came up, whether or not there will be some flexibility of the judge in terms of they can vary that. But I'm yet to get a legal opinion on what it is, whether or not the judge will say, okay, well, it wouldn't be a total of $5 million on 10 years. Or we might just give a fine. I'm hoping that it will be 5 years and $5 million and 10 years in prison. So that will be a deterrent from persons trying to get involved in these type of practices. Now,
let me ask you, I'm not sure how you may have been able to make a determination on this from your other experiences as to why you became the chairman of this office, that bid rigging is a real thing in Trinidad and Tobago's conduct of business?
I think if you look at some of the recent past in terms of the construction of a major facility in Trinidad, when bid rigging, persons were found guilty and appeared in the U.S. court.
Yeah. And
they pleaded guilty. So the answer, I would say, is yes.
The Americans pleaded guilty.
We have issues with bid rigging. And in the private sector, you do have it also. So it's not only unique to the public sector. And for years that we have been faced with bid rigging in terms of how you would find it working is that you would have 3 contractors and you rotate. In some of the industries, you rotate. So this contract I will get it, the next contract you will get it, and the other one you will get it. So you outbid yourself in terms of not wanting to get that particular contract, and the person who wants to get it comes in at the lowest bid.
Yeah,
those are some of the mechanisms that is used.
Yeah. So you're talking about an existence of what I envisage as sort of cartel operation.
A cartel operation. That's how it's one of the ways in which the bid rigging takes place. The other way that you find it is that you register about 3 or 4 different contracting firms with the similar type directors and shareholders, and you literally set it up in such a way that one of those firms will win. So there are different ways that you can do it.
Yeah. What do you say about the presumption that people, in this office, and we're talking about, you'll have to have investigators and so on, of the integrity of these people, such that they would become impervious to
we are very careful. You cannot be too careful, Andy.
Yeah.
But what we have done is we have a very rigorous interview process. In fact, we have a 2-stage interview process. After the interview process, we do background check. In terms of having an investigator do background checks on everybody, from my driver come right up. We do background check. We do character reference checks. And if anything comes up, the slightest concern, we would not go ahead with the recruitment. The other thing is that if you are involved in terms of the board or any member of any committee and so on, and you fail to disclose things like your interests during an investigation, there is conflict of interest and so on, you can be fined $500,000 and 1 year in prison.
And then the contract or whatever it is can be nullified.
Of course, yeah. So if you, a member of my board or subcommittee, is found guilty of any one of these things, they will be held accountable also.
Yeah, but you're saying that in your rollout to the groups and individuals you've been meeting with thus far, that some people have some difficulty accepting the purview of the office and the powers under your.
But
your remit.
some of this skepticism is that, well, this has to go to the DPP and then the courts and all these things. So it's a long, convoluted process and all these different things. But I am willing to say that we are going to follow the Act and make sure that whatever happens, we have a good airtight case, and we will go through the court process if we have to, according to the Act. But we are bent on making sure that what is required under the Act is followed. Now, one of the questions that was raised is in terms of who is responsible for procurement.
Yeah.
And I need to state this because this is very important. Any person who contravenes a section referred to in the first column of Schedule 1 commits an offense and is liable on conviction to the penalties specified. And the penalties I mentioned is like 5 million, 10 years in prison, and so on for different things. For the purpose of this Act, a public body shall have a procurement officer who shall be responsible for public procurement and the disposal of public property for that body, and shall be notified the office in writing. A reference to the Act to the commission of an offense by a public body shall be construed as a reference to the commission of an offense by the procurement officer. However, or an officer who purports to act in such a capacity. So if somebody takes on the responsibility and directs the procurement officer who is responsible for doing procurement at whatever level in the organization or outside the organization, they would have committed an offense.
Yeah.
So procurement has to be done and disposal of public property by the procurement officer in that public body. It's very clear under Section 61(2) of the Act.
So it appears that in more cases rather than less, public organizations must have a procurement office of its own, and a procurement officer at least.
It is mandatory. Now, they don't have to be named procurement officer. They could have another position, but they have one of their core responsibility is to be the procurement officer. And we would want to think, because of the importance of that role, that that person is sufficiently senior in the organization to carry a certain amount of weight. Yeah. Between the procurement officer and the accounting officer, you will have a procurement and advisory committee that would advise the accounting officer based on recommendation from the procurement officer. So whereas a number of boards would have been involved in procurement activities and so on in the past, we are trying to dissuade that, because what is going to happen is that we want to make sure that procurement is done as an operational issue. The board will have their role to play in terms of governance, approving the handbooks and guidelines to that agency, and to make sure through the audit committee or whatever other committee that they follow through on what is required under the Act.
Yeah. So in a lot of cases, some that I came a little closer to in the 5 years that I was a government working in a government agency as CEO, and I saw it, how I got insights into how it happens. Sometimes the procurement process itself could be sort of arranged, so you're going through the motions, but really the intentions and the outcome, somebody would have known what was desired outcome to begin with, and
that's basically bid rigging. You design the operations in such a way that persons who you want to win this bid, and you do everything in your power to make sure that the outcome is as you expect, and not following due process in terms of transparency. The handbooks and guidelines will be very, very clear as to what is required to make sure that you go through the process. And if you are in breach of the process, as indicated in the handbook guidelines, the Act and the regulations, the contract could be nullified. And the persons responsible for bid rigging will be taken before the courts.
All right. 222-8255 and 612-8255. Those are the numbers to call if you have any interest in joining the discussion. My guest is Mr. Munilal Lalchand, Chairman of the Office of Procurement Regulation in Trinidad and Tobago. And you were saying at that forum, as well as I think you mentioned it earlier, that there are some of these bodies who now fall under the ambit of this Act who don't see why they should be.
Yeah, some of the bodies are saying, well, we don't think we should. But the Act is so clear that says either under the definition of a public body or the definition of public money, you do fall under the Act. And therefore, why should some people who spend money or public money be responsible for reporting under the Act and others don't? It is across the board, and the Act is there now to make sure that public money that is being spent in whatever form or fashion must be in accordance with the Act.
Yeah, and I think you said at the forum that in some cases, some of these organizations and agencies sought, what I would call self-interested legal advice, who told them that they didn't necessarily fall there, but when they went to independent advice, in each case, the independent advice told them that you fall under the Act. Some of the bodies, they are more than 50% directly and indirectly owned by government. Therefore, you do fall under the Act. So you can't use that as an excuse that you don't fall. The other thing I'm very happy with, I was listening to a program on radio, and somebody from the Credit Union League, I think is a Mr. Remy, I'm sure it was. Yeah.
And he was mentioning,
president of the Credit Union
he says, we are trying to engage in terms of educating our credit union to fall in line with the Procurement Act. And I say, wow, that is where we need to get as a country. So they don't need to, because they're not a public body, but this is best practice. So my position is that all public bodies, or not even public bodies, this is best practice. Why don't you fall under the Act and try to get involved in doing procurement in a very transparent and accountable manner? And I think the country will benefit.
Yeah, and some NGOs whose existence is largely or greatly dependent on public funding, they have to conform to. They
have to conform to the Act, and we are developing special guidelines to help the NGOs to manage that process. And we are also encouraging professionals like in the Institute of Chartered Accountants or the Institute of Internal Auditors, members, if they can work with these NGOs to bring them up to a certain level of competencies, that will really benefit the NGOs.
All right, Charles, let's see if we have any calls at all. Yeah, so good afternoon.
All right, so people, the lines are open at 222-8255 and 612-8255. We just have like about 4 or 5 minutes, so you need to call. You need to do it right now.
The Prime Minister made a statement recently, and she was saying that there's corruption in our very core of behavior in Trinidad and Tobago. You think this will, this act and this office in operation will deal a significant blow? Yeah.
You have the commitment of the board and the management of the OPR that we intend to do all in our part to make sure that it makes a difference. But I was looking at some things that you have on your notice board there, the power of the people and the power of you.
Yes.
That is what's going to make a difference. The power of the people to make sure that this act works. The people need to rise up and demand of our office and demand of our politicians and public bodies that they follow the act and hold them accountable when they don't. And I think it's going to make a difference.
Yep. And so going forward, let's stay with that point a little bit, that perhaps up until this point, people came to feel that there was no point in pointing things out and in raising red flags because it would get nowhere.
See, previously there weren't any consequences. Now, if you are aware of collusion taking place and you fail to report collusion, you can be charged. If somebody reports the collusion, and as a member of a board or management, and you decide that you want to victimize them, fire them, you will be charged under the Act. And there are severe consequences. And if you decide to conceal or destroy information required for an investigation, the penalty for that, if found guilty, is $5 million and 10 years in prison. So all these mysterious fires and rat-eating documents and so on should be a thing of the past. So there are serious consequences, and I believe this will be a deterrent. And it is dependent on the population at large standing up and saying corruption should be a thing of the past, inefficiency, and these things should be a thing of the past. And that's how we will get it done.
Yeah, and you referred to cases in which so there are some cases in fact happening now. We have a call. Good afternoon. Yes, good afternoon.
Caller, take down the volume on the radio.
Hello.
Good afternoon.
Yes, caller, we're hearing you. Go ahead.
Hello.
Yes, good afternoon.
Regarding whether Cabinet can form a committee purchase or go out for tender for any item. I'll listen off it. Thanks very much.
All right. Thank you very much. That's somehow related to this issue about going to buy boats for.
Yeah. What we are saying is Cabinet can decide what they want to purchase, but the mechanism, once you hand that over to a procuring entity, and that's where you're supposed to hand it over to. The expertise for procuring activity should be in the public bodies that is designed and have staffing for that. Once it's handed over, there should be a hands-off approach in terms of the process that needs to be followed in terms of the procurement activity.
Yeah, and probably have less than a minute, or we haven't gone over time yet. But one of the questions you responded to at that forum was the extent to which this act has retroactivity.
And we sought senior legal counsel in terms of the retroactivity, and it depends on the nature of the exercise. If it's an ongoing procurement activity, then it could be investigated based on the fact that it is continuing, it has not been completed, but under the process for which it was entered into force. For example, if it was under the Central Tenders Board Act or any other procurement policies and guidelines that you would have used for the procurement activities.
Yeah.
So we are hoping that that is good, solid legal opinion that we got.
Yeah, and there have been a couple of instances in the last few months where documents went missing with matters that are under investigation. So it is possible that these things could be raised and could land up on your desk.
It could, and I want to hold all further comments on that one, just in case we have to get involved with it.
Yeah, I think you'd given that response to something that somebody asked about. Yeah.
Take a call, Andy.
Good afternoon. Hello.
Classic.
Yes, good afternoon.
Yes, good afternoon.
Yes, sir.
Based on the conversation you're having, right? Hello?
Say what?
Based on the conversation you're having.
Yes.
You're talking about public procurement, right? From
Yes.
a government perspective.
Yes.
Right. Was the National Tenders Board, the Central Tenders Board, that was the main function before they brought in all these special enterprise purpose companies, was that a fact?
Yes.
And secondly, I'm glad I'm hearing that, there are fines for procurement, but usually with these procurement, the people involved, government officials, big businessmen, financiers, whatever, I'm just wondering that, I heard the gentleman say that, like there are fines like 5 million and 10 years in prison, but how does that factor in when we have legal minds on a senior level involved, government officials? How does that translate into somebody actually facing the courts because of this? Because we hear, same with crime, we hear about it all the time, but the people who are the top who involved, you never hear anything about a probe taking place or investigation taking place. Because the best of my knowledge,
I think we get your point. We get your point. How is it going to make a difference? So you want to see people brought before the courts. The big fish is an editorial in the Guardian this morning about that.
Yeah, we let me just say that under the Act, once it's fully proclaimed, the Central Tenders Board is no longer in existence. It goes away. And in terms of prosecution and so on, the caller is quite right that sometimes these things come up in the public domain and nothing happens. Well, now we have an opportunity to take it the full length, and we will be engaging forensic accountants with the necessary expertise to do all the paper trail and working with whatever agencies we have to work, both local and abroad, to make sure the persons involved in these activities are brought to justice.
All right, we have a final call. Good afternoon. This is State of the Nation. Oh, well, that's it. Well, thank you very much, Mr. Munila Lalchand, Chairman of the Office of Procurement Regulation in Trinidad and Tobago. Thanks for listening. Thanks for your call. I'm Andy Johnson. Good afternoon. But up next, David Mohammed's commentary, and then live at lunch. Stay with us.
State of the Nation, 12 noon to 1 p.m. on News Power 102 FM.